Good afternoon, everyone. They've done a slide for me. My name is Helani Galpaya. I'm the CEO of LIRNEasia. Thank you for coming to this event, which is to launch, we've been doing this roadshow in it's a 7-country research that we did, and this is sort of the launch of the Sri Lanka one, so we will have regional perspectives. But we do a lot of work on using AI in a lot of our work, using data for public policy. And we were thinking, every time we try to access data, for example, whether it's public data, sometimes negotiating with the private sector, there's a whole lot of untangling we literally need to do at contractual level. Is it allowed by policy? Is there privacy violations? All kinds of challenges just at a practical level. And then somewhere along the way, Sri Lanka also passed the Data Protection Act. But data being what it is, it's this artifact, a representation of the world that has been around for many years on paper and then in digitized form. There's a whole lot of laws and policies that govern the way that we can use, access, reuse, share data, right? Because it's not this new phenomena which we developed a new law to govern. It's just a hodgepodge of different laws, policies, norms, and practices, and helped or hindered by new technologies, right? So it's a complex thing, and we thought we should actually just sit down and look at how on earth are countries in our region dealing with data, particularly now that machine-readable data, machine learning and artificial intelligence is a big thing. We are all trying to use it to leapfrog and catch up with other countries. Data is one of those primary inputs, right? How is it governed? What are the complexities? What are the conflicts between the different laws? So like, when you're trying to protect privacy versus when you're trying to open up. And how are we resolving those conflicts? How are these laws made? That's kind of the angle we came at this. So today we will present sort of what's happening in 7 countries across Asia that we looked at. Give you sort of an overview. Pranesh will start us off. He's written a regional synthesis. The QR code is in front of you. Then we will hear from Ashwini Natesan, who was the research fellow for Sri Lanka. Many of you know her. And she will present Sri Lanka specific findings. We will then bring 2 more of our colleagues, Ashwini and Pranesh, and the other 2 colleagues from Pakistan and Indonesia who did those respective reports, have a little discussion and have opportunity for you to ask a lot of questions from all of them, and in particular about the Sri Lanka study. I think everyone here knows LIRNEasia, but we are right now actually working in 22 countries, mostly on AI stuff, responsible AI and governance. That's why the country list has expanded. But without much ado, let me bring on Pranesh Prakash, the co-principal investigator on this project. He will actually introduce himself a little bit as well, because he may not be as well known as Ashwini, and then Pranesh, take us through. Thank you.
Good afternoon. My name is Pranesh Prakash. I was a co-principal investigator of this report. Some of you who've done work in the region and internationally around data governance issues and tech policy would know me as a co-founder of the Center for Internet and Society. And let me jump straight into the project. The Data for Development Asia project aimed to look at 7 different countries, and we did a little bit on South Korea as well, so 8 countries, but all of them in South Asia and Southeast Asia, developing countries. And when we launched this study, we asked ourselves, why are we studying data governance? To an extent, Helani already provided us the answer. What is data governance? How we go about studying data governance, and what the special considerations are in developing countries in South and Southeast Asia. Now, why is data governance important? Well, primarily because technology shapes our lives, and how data is governed is very important for how we exercise our rights, for how it impacts our lives in various ways. And also it's important for good governance and development. Now, technological advancements always require changes in social, in our society, in politics, in economics, in law. And I'll just take you through two examples to kind of set the tone for what I mean. One is privacy and the evolution of privacy as an idea, and two, the evolution of transparency. Now, even in the era of oral cultures, we've always had a notion of privacy. The first example here is notion of privacy as confidentiality, in terms of confidentiality between two people who are having a private conversation. A third party should not be interfering and eavesdropping upon that. But then with mass media, with the evolution of writing, things change. There's a breach of confidentiality as a tort that arises in England in the 1800s, including letters involving Jonathan Swift, and those being published without permission, and issues of copyright also gets involved in all of this. So with writing, even with letters, things change. New legal rights get defined, new laws get defined by courts. In 1890, there was a landmark paper in the US called The Right to Privacy by two legal scholars. One of them is a judge, Branson Warren, where they defined privacy as the right to be let alone. This comes about because of technology, because of the technology of photography. With photographs, you have paparazzi who are climbing trees and trying to take photographs of rich people having post-wedding events in their backyards, and paparazzis are trying to take photographs of that. And what they realize is there's nothing we can do. There is no law we actually have to prevent this from happening. And so they assert a new right. And that is needed because of changes in technology. Similarly, from the 1970s and 1980s, with the evolution of databases, we've had a specific law and legal and policy response in the form of data protection laws. So you have these coming up in the 1970s in the US, in a few European countries in 1983. The Council of Europe comes up with data protection law. And so this is a specific response to a specific technology, not just digital technologies, but databases in specific give rise to the need for data protection law. And even data protection law itself hasn't been static. In the 2000s, it eventually evolved until 2010s in the Costea judgment in Europe. They decided there is a right to be forgotten. And why does that need to be asserted? Because now we have publicly searchable databases through search engines. So if search engines did not exist, the question of the right to be forgotten would never arise, and it actually never arose. Even in the 1970s and 80s, when data protection was a concept, the right to be forgotten wasn't, because it needed the evolution of search engines being widely adopted before we had that. Similarly, with transparency, there are limitations to what you can put out publicly when it comes to transparency as a government. So transparency laws have mostly been reactive laws, where a citizen asks a question and the government department has to respond. But now, in the last 15 odd years, the idea of open data has really caught on, because through websites, through standardized technologies, through open standards, through open APIs, you can make much more information publicly available. So what transparency as a government means has changed because of technology. Now coming to what is data governance? Well, it's a neologism, you don't need me to tell you that. It's construed differently in different domains. If you search for data governance, all the top hits in your search engine will all relate to the corporate sector. How do you manage data and data flows within the corporate sector? That's what the top hits will be, some results from IBM and things like that. But for our project, we are focused specifically on public policy. So we are not looking at an expansive definition of data governance when we're looking at data governance. And in public policy, it really boils down to governance of data. But this also helps establish guardrails. So don't expect to find much discussion, for example, of censorship and different kinds of techniques that governments have used to regulate social media in the report. We said, no, we're focused on data governance, and we haven't gone far beyond that remit. But even while studying data governance, what we realized was lots of different people are using this term without saying what it means, and different scholars have used it to mean different things. In most papers on data governance, you'd find people essentially talking about things like data protection, that being the main focus, or otherwise cross-border data flows being the primary focus. And we realized that's not what we want to do. We don't want to piecemeal take on a few things and just call it data governance. There has to be a systematic way of approaching this question. And so we divided into two separate areas. One, things, laws, policies, technologies that increase access or openness for citizens. This would include everything from open standards, open source software, open data, open APIs, open content, including access to scholarly literature that the government funds, archives, and so on. And I'll go through all of these in greater detail in a minute in case you don't know these terms. But this is one set of things, increasing access. The other would be decreasing access for citizens. Now, this isn't necessarily a bad thing, because we need laws that protect things like privacy. That's decreasing access. We need laws relating to national security that are often take the form when it comes to data governance of data retention laws, data localization laws, restrictions on data centers, and so on, access to data for law enforcement, and so on and so forth. And lastly, there are restrictions placed on data when it comes to property-oriented rights, things which are property-like or quasi-property, like things like copyright, things like database rights, and so on. So what we realized is these are two broad buckets, but both of them are absolutely required. You need policies that increase access, and you need policies that decrease access. These are fundamentally in tension with one another. Okay, you can't have, you can't just maximize both at the same time. They need to be carefully calibrated because of the fundamental tension. And the other thing we did was engage in some amount of comparative analysis to essentially say that the European Union and what it's doing is often setting the model for the rest of the world. This is both because it's easier for companies to comply across the world if there's a single set of regulations they need to comply with, and also because countries, when they're looking around for examples, the EU is first off the door, right? Like they've set a standard, and others tend to copy, and that's not necessarily a good thing, because there are differences in ability of private sector to comply. Your companies might not be able to comply with European standards. There are differences in state capacity. Your government might not be able to implement European standards. So we really need to think beyond the Brussels effect. So I'll just go through our main findings quickly, and this is for across all the countries that we've studied, and then I'll hand over. So in increasing openness, when it comes to open standards, now open standards are technology-oriented standards, protocols, which are royalty-free. You don't need to pay for them. And usually these are openly specified. You can see them publicly. It's on a website, what the standard is. Anyone is free to implement it, including people developing open source software. And this is important for everything, from accessibility for persons with disabilities. There are standards set by something called W3C, called WCAG, which are accessibility guidelines. To business reporting, there's an open standard called XBRL, which some countries have adopted, which requires companies to provide information about their balance sheets and so on to the company's authority in a particular format to make it easier to actually work through it. Tax reporting standards. These are things that are developed in bodies like ISO, IEEE, W3C, and so on. Now, few countries have policies. India, Indonesia, and Philippines actually do have policies. None have a law requiring open standards despite these policies, and none of these are enforceable. India and Nepal go a step further. They have a list of e-governance standards as well, and none of them do a good job of enforcing any of this. Free and open source software, all of you know what it is. The software that comes with multiple freedoms associated with it. You're free to run it for whatever purpose. You're free to study it, so you need the source code. You're free to modify it and to pass on those modifications to other people. Now, India has multiple policies, both at the national level and state level, around this. None of the other countries have policies around this. In India, we even go a step further, where the government has a GitHub-like equivalent for government-created software. It's called OpenForge. Some departments are actually using it, but it's not as open as it should be. The best examples in this actually come from other countries that were not included in our study. The USA has done a good job. There's code.gov. Switzerland and Germany have also done a good job. Multiple states within Germany have gone full open standards, open source. They've abandoned paying the Microsoft tax and gone fully open source within the government's departments. Right to information. Now, multiple countries, actually all the countries, have constitutional protection for the right to information. In some it's explicitly there, in 6 it's explicitly there in their constitutions. In India it's read into our constitution. Sri Lanka and India actually provide the best example on this front. With multiple, the things have not been so great in India in the last say 5-10 years, because there have been lots of administrative problems created. The RTI Commission has been without a commissioner for a long time. They finally appointed a commissioner after years of delay and so on and so forth. But India, for the first 15 years of the implementation of this law, it was seen as or first 10, 12 years was seen as an example, as a great example for other countries as well. But Sri Lanka has been doing a good job relatively compared to all other countries in the region, definitely. Open data. This is data that conforms to that's an open standard and is published openly online so that no one has to pay to access this data. Every country except Pakistan and Nepal have a government-run open data portal. In Pakistan, there's a private open data portal run by a university, no government-run one. And in many cases, it's quite fragmented. Different departments are doing their own thing. There is no uniformity. There is no central portal through which you can access the information in different government departments and so on. The good examples in our region were Indonesia and India. And the best example globally, I would say, is probably the United Kingdom. They do a really good job of promoting open data and using open and making it available to everyone for all kinds of uses. And the civic society in the UK has also done a great job in terms of actually using it. And apart from civil society, even the private sector has done a great job in the UK of actually using the open data that has been put out by governments. Open APIs. Now, APIs is a bit of a technical term. Some of you might not be familiar. This is essentially a programmatic way of accessing things on a server. And what that means is when you want data in bulk, in a way that's easily accessible for developers, you need to provide an open API. Now, India does a decent job of this because they've addressed two issues. One, multiple departments actually provide open APIs, but also the central government runs a website where they catalog these different open APIs. So they say these are all the APIs that developers can access from these different departments, and that catalog becomes very important because it allows for discoverability. And India is also pushing for this idea of digital public infrastructure, which we'll talk about more later. So India is kind of leading on this front in the region. Now, let me also just add that a genuine digital public infrastructure would rely on open standards, free and open source software, and open APIs, all the things that we've spoken about. Decreasing openness. Now, data localization is something that's using a hammer when you need, fine surgical tools. It's most pernicious in India and Thailand and the Philippines. Lots of different policies and laws which impose data localization requirements, saying that the data must not only be within our jurisdictional reach, but physically located in our country for various purposes. As we'll discuss later, that's completely useless as a policy tool. Data protection. A fine balance needs to be drawn when drafting data protection laws to balance the requirements of privacy and security, and to avoid stifling research, free speech, innovation, archiving, and so on. And our study finds that none of the countries we've studied actually do a great job of this. And copyright, again, we find that striking a delicate balance between quasi-property rights and openness is quite difficult. And free speech often gets impacted in most of our countries. Innovation gets impacted. In most of our countries, Philippines being a notable exception, search engines are technically under the copyright law unlawful. So every search engine is actually violating copyright law. And AI is also unlawful in most of our countries. Whether search engines are legal in India, they probably are, but AI, it's a tougher call. And so AI that depends on collecting lots of data in order to train models, a lot of that would violate copyright law in all of our countries. And last thing we looked at was the policy-making process and how open that was. And here I must stress that the policy-making process, when we're talking about openness, is not just about transparency of the process, but also the responsiveness of the government departments to comments, the public justification, and this is terribly important, that is, whether when there are hard choices to be made and trade-offs which are inevitable, as I've explained, do they justify what position they've taken and why they've taken the position that they've taken? And the articulation of these trade-offs as trade-offs, saying that we faced a tough choice between these two, and here's why we've made the decision that we have. None of the countries do well overall. In different countries, specific departments on specific laws have had very open policy-making processes, but none which do a great system overall. South Africa is a good international example in this front. They have a green paper, white paper system, where first they put out a draft of what the laws attempting to do and invite comments, and then based on the comments received, they then provide a draft of a law. So they don't just straight jump into a draft of a law, as many of our countries do when they're asking for feedback. They have a green paper before that point. I'll just conclude by saying that what I've presented right now is a very, very, very short summary of a much longer report. This report itself is 80+ pages, the synthesis report, and apart from this one report that compares and provides you a summary of the entire region, each of the countries has a very detailed report, both of the laws and policies and so on around data governance in their countries, as well as detailed case studies where they've looked at the kinds of tensions that exist in these policies. They've looked at how the government has responded or hasn't responded to these problems. And so please do take a look at all the country reports. And I'll just add that a novel contribution of our study is that we provided a systematic way of studying data governance. And it requires looking not just at one thing like data protection laws or cross-border data transfers, but a host of different policies and laws. And so now when anyone is looking to see what impact anything has on data governance, they'll realize that there's a whole lot of different policies and technologies and laws that they really need to look at. And last 2 points, no country in our region, and no region generally, not the EU, not the US, has all the right answers. Our requirements are different, state capacities differ, ability of companies and so on, the private sector to comply with regulation differs. And so no one has all the right answers because there is no one right answer. There is no right solution, only trade-offs. All economists know this, but many policymakers haven't internalized this yet. But what's very important is not just to say, oh, there's no right solution, so any solution will do, but to articulate what the trade-offs are, to carefully study them, to discuss them, to then publicly justify why you've taken a position that you've taken as a policymaker, and so on. So, let me just end it here, and we'll have a round later where we are able to discuss this with other experts from the region. And now let me just ask Ashwini Natesan to present the findings from the data governance research in Sri Lanka. Thank you.
Very good evening, everyone. It's a pleasure to be here and to be addressing something that we worked on for nearly 2 years now. We started this research in mid-2023, and today we are in a position where we are able to share the findings, so it's really come a full circle, and I'm glad to be here. So, as Pranesh mentioned in his presentation, when we look at data governance through this particular framework that we have devised for this study, we look at it from the point of view of, or the dual point of view of, increasing access and decreasing access to data. And to just give you a snapshot of some of the laws that we have looked at when it comes to increasing access, it's the right to information, it's the National Archives Law, we have the Survey Act, we have the Census Ordinance, we have CRIB, and we also have the Anti-Corruption Act. All of this have been studied in our report in detail. And when we look at decreasing access, we look at it from the point of view of security, where we see the Sri Lanka Telecommunications Act, Computer Crime Act, Public Security Ordinance, Online Safety Act, and of course, we also study the Personal Data Protection Act and the Intellectual Property Act. And just to rehash your memory to what Pranesh said in his presentation, decreasing access in the context of our research is not in the negative connotation. We're not here to say that these laws are restrictive in nature, but we're just pointing out that these laws are also essential. We need laws that will restrict access because there are situations where we need to protect data. We need to have data that should be restricted if there is a threat to national security, for instance. And that is how we've just distinguished this study on this basis. I must also mention the limitations of the study, that is the report in itself, but this does not mean that we will not be discussing any of these recent updates in Sri Lanka during the discussion and during the forum later on. But in the report itself, you will see that some of the latest updates may not be available, but we have made an effort to update it as late as even in June 2025. So we do have the cloud draft policy included in our study, but some other updates may not be there. Like I said, because the research, a majority of the research was conducted in late 2023, mid to late 2023 and early 2024. So that's something that you have to keep in mind. And some other amendments and shifts in terms of the powers of the digital economy ministry, etc., may not be found in the report for this reason. And the other point that I also want to mention is some of the draft policies that we have mentioned in this report may not be accessible in the official website. For instance, in the ICTA's website, you may not find them, because when we did the study, they were still accessible, but right now, due to policy changes, you may not still find them in the websites themselves. So that's just a rider. You already know what our research questions were, so I'm not going to spend much time on what these research questions are. Instead, for the purposes of today's discussion, I've culled out 3 of these research questions, which I think are very important, and which will also help you drive home the point that we want to make. First is the fact that friction exists between different policies or laws. So there are going to be areas where there are conflicts, and we all agree with that. But what are these conflicts? How are they hindering with the overall framework of data governance? That's the first. The second one is the process in which laws are being developed. Is there uniformity when it comes to public consultation? What are the processes that are being followed? That's the second point of focus. And the third one is certainly one that's been discussed many number of times in discussions such as these. It's on capacity challenges. How does Sri Lanka address these capacity challenges? And by the end of this presentation, I hope that you would get an idea of how these aspects have been looked into, and we will give you examples for each of this. And for each of the findings, there are several more examples that you can read in detail, but even in today's presentation, I would be giving you some examples to drive home each of these points. And the first is friction points between different laws and policies and how they are being worked out. When we say how they are being worked out, it can be understood that these conflicts are recognized and they've just let it be, nothing has been done. Or the second instance, they are not really being recognized. And so what's the cop-out? What's the workaround when there is a conflict between existing laws? The first that we see in almost all of the recent legislations is what we call as an overriding clause, or a non-obstante clause as we would call it, simply saying that this law will prevail over any other law that exists previously. So you have an overriding clause in all of these legislations that we have looked at, on several of them at least. Not in the older ones, but in the newer ones, there will always be a clause that says, if there is any conflict, this particular law will take precedence over the other. So one way to consider this is, so the legislation passed in 2022, and there's a legislation passed, a law that's passed in 2025. Both laws, in all probability, will have this notwithstanding clause, or this clause that says, this particular law will override. What happens in that case? The one that's later in time will prevail over the one that's earlier in time. So that's something that's been included in many of the laws. One other way that we see is concerns are being worked out, and there are ways and means through which efforts have been taken to address these concerns. And one very good example that we've noted was the one relating to the National Archives law that's being looked at for amendments. And when we spoke to our key informant interview relating to the National Archives law, what we found was that in the framework that was put out for public consultation, they specifically noted areas of conflict with the Personal Data Protection Act and with the Right to Information Act. And they also brought in provisions to say how these conflicts would be resolved or how they will be looked at. For instance, they said, the provisions relating to access to data, or the provisions relating to maintenance of data, or the legal basis for processing will then be given as exceptions. They would not really apply when there are archive-related issues, because archiving is being done in public interest. And if it needs to be maintained for a period of time, which is beyond the purpose for which it was collected, it can still be done. That's just an example in which, where you do have conflicts, but it's being worked out. There are ways and means through which they are looking to address those conflicts. And when we had a discussion with the Personal Data Protection Act, the Data Protection Authority member, who was also our key informant interview during the process of this research, we noted that there were certain conflicts that were raised, and the key informant interviewer also agreed with it and mentioned that there are going to be advisory committees that will be appointed to look at sectoral related conflicts. For instance, Right to Information and Personal Data Protection Act. They will be worked out, is what we were told. So we do have examples where these friction points are noted, and they are also considering ways and means through which these conflicts can be addressed. But it's not always a case of having these conflicts being recognized and being worked out. There are instances where they have not been looked at all. And for an example of that, I would like to take Section 23 of the Electronic Transactions Act. Section 23 of the Electronic Transaction Act states the exceptions or the exclusions for the application of the Electronic Transactions Act. For those of you who don't know about the Electronic Transactions Act, I'd just like to say it's that enactment that gives functional equivalence to both paper-based as well as electronic contracts. So for instance, when you have a paper-based contract, through the Electronic Transactions Act, you have functional equivalence that you can enter into contracts online or electronically as well, and that's perfectly valid and it's acceptable. So we do have the Electronic Transactions Act, and in that, there is a Section 23 which says there are exclusions from the application of the Electronic Transactions Act, and this was brought in through an amendment in 2017. There's one particular provision which says if they relate to matters on foreign exchange transactions and it also relates to financial transactions, they will be excluded from the purview of Electronic Transactions Act. For those of you who know of the foreign exchange regulations in Sri Lanka and the relating instruments from the Central Bank of Sri Lanka, you will understand that Sri Lanka is a foreign exchange control jurisdiction, because of which, fair enough, it has been excluded from the purview of the Electronic Transactions Act. But this means there should be laws that permit for electronic transactions or electronically entering into contracts for financial transactions, including for foreign exchange, provided some conditions are fulfilled. But we do not have any such laws at all, and we do not have any directions, or even we do not have any guidelines from the Central Bank of Sri Lanka on this respect. So we do have this friction, and we don't have anything that exists to make sure that this lacuna is overlooked. We don't have anything, and now it's just being overlooked at present. And another example of an existing conflict that we have come across is through the information classification framework and the information classification policy. Now, these were publicly accessible previously, but the last time I checked, I was not able to see both, but you might still note that within that information classification framework, which was meant to give a guidance to public authorities on how data should be classified, specifically had a provision that said confidential data should not be disclosed. And the explanation to what a confidential data was included data relating to a person's salaries, benefits, and emoluments. Now, this is directly in contravention to the views taken by the Right to Information Commission when it comes to what can be disclosed. Salaries have time and again, especially salaries of public authorities, have time and again been ordered to be disclosed by the Right to Information Commission. Again, a friction point that has not been looked at. And we have several more examples, but I'm happy to give other such instances or examples during the discussion. And another problem that we have found is that several policies exist, but they are in draft form A, or B, even when they are not in draft form, they have been adopted, they just work in silos, they operate in silos without looking at other existing policies in that space. And I can give you an example. We have a national data sharing policy, which was accessible until shortly before. This national data sharing policy was drafted in 2013, and it still continues to be in draft form. We also have information classification framework, we have digital document management policies, and several such policies, all existing, still in draft form and have not been adopted. There's also a draft policy on free open source related software that should be adopted, but it's not yet been adopted. Having said that, while there is a draft policy recommending free and open source software, procurement guidelines always don't insist that free and open source software should be used. So we see there's a disconnect between the two. And another good example that I think, not that we're only pointing out the shortcomings, but we see a good example when it comes to the Sri Lanka government enterprise architecture. The one we looked at was version 1 that was out in 2023. And in this version, you see it was an example of a good master document because it looked at all existing and the future government initiatives, including Sri Lanka Unique Digital ID, Lanka Interoperability Framework, and also Lanka Data Exchange. All of this was contained in that one document, and it also looked at ways and means through which they can work together in coherence. So that's another important point. The second aspect that I want to highlight in today's presentation is on how laws are being developed. Is there uniformity when it comes to public consultation? And the answer to that, the short answer is, of course, no. We don't always have public consultation, and that's well known. But what we have done here is we've looked at a comparison of some of the laws, especially in recent times, to give you an idea of whether public consultation was conducted or not. And public consultation, in the previous slide I've just mentioned, is not just about having a window for public consultation. It's about timely notification. It's about accessibility. It's about inclusive participation and transparency and accountability. So based on these 4 yardsticks, you can see that none of the laws have really got it all right. But we do have the National Archives law. And at this point, I must also mention a very important observation that was made by the key informant interview. It was stated that we always call for public consultation, but the participation for public consultation is not really spoken about sufficiently. It was mentioned by the key informant interview that when it came to public consultation, they had kept the window open for nearly 45 days and they only received 13 responses in that span. And they also planned to have in-person consultations in all of the provinces in the different areas. And they actually went ahead to cancel them because there was so little interest in the public consultation. So while on one side, we have to require that state entities and when in the process of developing laws, conduct public consultation, it's also extremely important to highlight that the public should participate when consultation windows are open. And it's also something that is worth noting that it's not just about having a public consultation window, but the deliberations, the comments that have been received during the consultation should also be published. Now, that's a best practice, but in reality, what we've noted is even to get copies of draft bills, sometimes we need a right to information request, and that's just evidenced through this Right to Information Commission decision. And finally, the point on capacity challenges. We all know of capacity challenges. How are they being considered? Is it being tolerated, or are the laws being simplified to make sure that there can be meaningful capacity building initiatives? And in that, what we've noted is, for instance, under the Right to Information Act, there is a separate, initially at least, there was an independent line item in the national budget under the Media Ministry. But subsequently, what's been noted is that there is really, it's not only the question of not having money, it's really not the lack of money, but the lack of non-independent manner in which the funds have been allocated to the commission that has contributed to the capacity challenge, because I understand from the key informant interview that the Right to Information Commission functions with just one legal researcher. And also, when it comes to the training of public officials, there was it's been fragmented, number one, but the trainings that were first initiated in 2017 were very effective. But those officials no longer remain information officers or designated officers in the public authorities, and that has contributed to this problem of capacity when it comes to right to information, and that's again something that we have considered in our report. When it comes to the Personal Data Protection Act, a comment that was made by the KII was to consider ways and means through which we can have revenue that can be generated. But what we see is, in most cases, these capacity challenges are merely being tolerated, but they are not really looking at simplifying laws. In one instance, of course, when it was pointed out there were serious concerns when it comes to record management and archiving and the Right to Information Act, it was mentioned that they would consider ways through which they can simplify this and also ensure that the public authorities are able to manage records at the same time, and also consider ways through which archiving can be looked at. There's this point that I'm not going to mention now on generating revenue for the Data Protection Authority because it was mentioned, but if you see the enactment itself, it appears that any penalties that will be paid will be credited to the consolidated fund. So then it remains to be seen how we'd be able to manage with revenue generation. And finally, you may have seen that we have repeatedly mentioned the Right to Information Act and the Personal Data Protection Act. And the reason being, in our study for Sri Lanka, the two deep dives, that is, we have done a complete study on two legislations, and that is the Right to Information Act and the Personal Data Protection Act. One has been implemented and operationalized since 2017, and one yet to be operationalized. And the reason we did this is simply because to highlight most of these friction points that we've mentioned previously, but not only to mention that these exist in the case of PDPA and RTI, but also to raise concerns relating to these enactments. We don't have too much time, but I'm simply going to mention a few of these areas of conflict. Number one, the Right to Information Act is about disclosure of information, and the Personal Data Protection Act is, amongst others, to ensure that there is protection of personal data. On a surface level, there should be no conflict. And you might also be right in asking this question to me, because under Section 5(1)(a) of the Right to Information Act, wherever there is data that could be considered as causing unwarranted invasion of privacy, such information need not be disclosed. And you might say that is perfectly fine because that's what the Personal Data Protection Act is all about. Only thing, that's not the case. Because here we talk about, under the Right to Information Act, it is an exemption to that data or that information that would cause unwarranted invasion of privacy. But the Personal Data Protection Act is to protect all personal data, and the definition of personal data is quite wide. Then comes the issue of, since there is protection of personal data to all personal data, how will that work in the realm of information disclosure? Will that be used as an excuse to avoid information disclosure is a concern. While there is a general exception clause under the Personal Data Protection Act, which says when it comes to freedom of information and also right to information, there can be exceptions. In my opinion, that in itself will not be enough. We need to have more guidelines on how these different conflicts between the two legislations can be looked at. For instance, under the Personal Data Protection Act, you should only process personal data for specific purposes. Under the Right to Information Act, a person can request any information and no reasons need to be given. And it's not a requirement to only store personal data for a purpose, but you have to keep it for 10 to 12 years. So these are some of the areas that are in direct conflict, and we need to see how they can be worked out. AI and data is something that we're going to discuss in our forum quite, I think, extensively. So I'm not going to spend too much time, but I just want to leave you with one question. When it comes to training of AI models, will a Personal Data Protection Act be an impediment to such training models is something that you have to think about. And we look at what the Sri Lankan situation is, the Sri Lankan scenario is, based on Sri Lanka's Personal Data Protection Act in a little bit. Similarly, when it comes to IP, intellectual property rights, does it allow for training of copyrighted material for AI purposes? There are all kinds of copyrighted material online. Is it okay to use such material for training of AI models? Again, something that you have to think about, but I can give you the cheat answer. The cheat answer is no. Sri Lanka does not have any such provision. In the first place, even search engines like Google, which we all use, can strictly not be available in Sri Lanka because we do not have a provision through which we are able to use data that's already online, copyrighted data, for even search engine purposes. So you can imagine when it comes to AI, it cannot be. AI training models, again, it's highly unlikely we'd be able to use it with the existing provisions. What we need then is a widely worded exception clause for text and data mining. We don't have it, so it's not that we are recommending that there should be one. The question is left open to decide that if it should be allowed, it can't be done with the existing laws as it stands. I'm going to conclude, and in conclusion, we have some recommendations that we believe would be useful when it comes to building the institutional framework for data governance in Sri Lanka. The first is to harmonize conflicting laws and policies. Now, this is easier said than done, and I completely agree. How are we going to harmonize these laws? It's the suggestion that we should consider a legal audit. And through this legal audit, we have to consider and identify the overlaps and conflicts between the general laws and also the sectoral laws. There are many examples that we've discussed now, and there are several more in the report in itself. But what we want to say is a legal audit can go a long way in harmonizing these conflicts, and also institutional and structural reforms. So we ask for better coordination between Central Bank of Sri Lanka, the Data Protection Authority, the Right to Information Commission, etc., because there are many overlaps in the functions that they perform between these various regulatory bodies. And to, of course, have advisory committees. Finally, we also look at implementation of capacity building. Now, when I say have a roadmap for capacity building, it's not that we've not had such initiatives in the past. We've had initiatives in the past, but right now we are at a point where we certainly need more capacity building because there are obvious conflicts between the ways in which the various laws will be implemented, be it the Right to Information, be it the PDPA or the Anti-Corruption Act for that matter. And public engagement and transparency, like I've always said, here when we look at meaningful public consultation, that would make a difference, not simply a consultation through which there is a the public are able to send their comments, but those comments are not made public. And also, the window for the consultation is much lesser, and it's not accessible in all languages. And finally, monitoring and evaluation of what recommendations have been taken in and what has been done. All of these are quite important. One is not mutually exclusive of the other. So on a concluding note, we do hope that this study will be the starting point of many such initiatives where we would look at these laws in detail. We've tried to look at each of the research questions, particularly when it comes to conflict, capacity building, and public consultation in great detail and depth, and we do hope that this will influence and also support studies in this regard in the future. Thank you very much, and I'm happy to answer any questions you may have.
Thank you, Ashwini. While we're getting the chairs for the panel, you have the bios, but Ashwini from Sri Lanka led the work here. Aslam Hayat, who is a research fellow at LIRNEasia, comes from telecom, legal background, did the work in Pakistan. Sakti, who is a comms, PR, and legal professional, did the work in Indonesia with another colleague of ours. Pranesh looked at the regional findings overall as co-PI, but also led the work in India. So we'll primarily focus on these 4 countries. Can I invite the speakers to come? And Semanta, my apologies, from Nepal, led the research in Nepal, and he's also a lawyer. Come. So I thought we'll start off our discussion, well, sort of just to set, I guess, the priorities, what I wanted to discuss with you, and that doesn't mean we can't, ask any kind of question, but sort of center this around 4 things, 2 of which I think are really quite relevant to the moment Sri Lanka is in, which is sort of how do we make data accessible, enough data to enable innovation, transparency, and to make government work better, sort of the open data question. Then there's the question which seems to be quite relevant in the center of many minds, particularly, let's say, Pakistan and Indonesia, but also getting a lot of traction, this idea of data sovereignty, us having control over our data as the second sort of discussion thing. The third are around these new challenges because of AI and data protection. What is it that we can and cannot do? And the fourth is related to where Ashwini ended, which is when copyright regimes come in, what we can and cannot do. So that's how we will structure sort of the 4 parts of our discussion. Yeah. My sense, certainly sitting in Sri Lanka, is that on the first topic of open data, we're doing a really poor job. Is that right? I guess I'm going to ask the sort of Aslam and Ashwini to answer this question, to say how are our countries doing when it comes to opening up data? And you can think about opening it out to the public, but also data sharing between government departments.
Thanks. Thank you, Helani. So when it comes to Sri Lanka, like I said, open data, we do have a platform called data.gov.lk, and through which we are able to access some open data sets. But the problem with that website is that many of these data sets are still dated, and up until last year, the latest data set that was updated was in 2022. This is up until 2025 February. And in 2025 March, we have one data set for 2024-2025 that has been updated. So when it comes to that open portal, I think we've not really done very well. But what we do note is that we do have a draft policy on free and open source software. So there is, for open standards in some way, they pay some attention, but not enough. And during my presentation, I mentioned that we do have a policy, a draft policy at that, but then it's not translated to procurement guidelines, for instance, or procurement notices that says we're going to prioritize free and open source software, for example.
So does the fact that Sri Lanka recently got kicked out of the Open Government Partnership actually mean anything, or is it just optics?
So we got kicked out of the Open Government Partnership because we did not file annual reports for 2 years. And it's very sad that it is the case, because it was one of the founding members. And the Right to Information Act itself was passed as a way through which the open government principles will be achieved. And we've done quite well when it comes to the Right to Information Act. But I must mention that when it comes to proactive disclosure under the Right to Information Act, and we've had various research studies by other organizations, it's always been dismal. And in one way, we can consider that from where we started in 2017, 2018 to 2025, there's been improvement when it comes to proactive disclosure, but still very poor when compared to other jurisdictions that have worked very well and have set an example for proactive disclosure.
So this point about, open government policies and these partnerships were meant to be proactive, as you said.
Yes, also proactive.
Right, which hasn't worked, and what we normally think of as right to information is this reactive, on-demand disclosure seems to be actually helping a little bit, while the proactive idea didn't quite work.
Yes.
And I kind of get the same feeling from Pakistan and Nepal as well. It's RTI that's actually driving even the little data that is available. Is that right? Maybe Aslam and Semanta.
Pakistan and Sri Lanka has a very friendly relationship, and because of that, they were not the only one kicked out of Open Government Initiative. We were with Sri Lanka all the way, shoulder to shoulder. And the reason for that is that it's not that Pakistan is not publishing data. It is being published under the Right of Information Act, and actually there is a section 5 which specifically lists down a couple of things that those things has to be for every ministry and the department. Those information has to be published on their website, and that includes basic data, laws, policies, the government structure, decision making, and all this stuff. The reason obviously for being kicked out was that we were not proactively reporting. There is also a database which is available that's not managed by the government, but it's managed by a university, as Pranesh mentioned in the beginning. Unfortunately, that database is also outdated. Some of the data which is available on the websites of the different, for example, on the telecom sector, on the financial sector, that is updated up to 2025, but this database, which is supposed to have the correct data and updated data, that some of these is to 2016, 2019, and nothing after that. So it's not very useful over there.
So Semanta, in Nepal, the situation is similar, but you get at some of the reasons people say they can't put data out, like your National Statistics Agency, which is meant to be doing this, right? What are these?
Thanks. I think Nepal never joined the Open Governance Partnership, so we didn't get an opportunity to get kicked out. So 2 more points, I think, regarding this tension between proactive disclosure. You did say that reactive disclosure really works in Nepal, but I'll also cite one case recently that Supreme Court had to hear regarding proactive disclosure under RTI and compare that to the right to privacy under the Constitution and under the laws. The way it works in Nepal is in a driving license examination, there is always an irregularity that happens and people clear the exams with different processes. But then because the examinations were questioned, the driving license department started announcing the results of the people online with their information, including their citizenship certificate number, the names and everything. Then one gentleman filed a case at the Supreme Court saying, you've started, saying who cleared the exams, who failed the exams online. That goes against right to privacy because my information that I flunked the driving license exams should not come on a government website. And the case was filed before the Supreme Court. Supreme Court just announced its verdict saying that, and the issue that was in contention was the definition of personal data, which included citizenship certificate. But the results that were announced only did not give the citizenship certificate, just gave the citizenship number. So the government started defending, saying that I have not released the citizenship certificate, I have just announced the certificate, I have just given the details of the citizenship number, so that does not breach the right to privacy laws. But then the Supreme Court arrived at a decision saying, citizenship certificate means also the citizenship number. So because of that, you should not be disclosing such information publicly on the government's website. So that is the tension, I think, that Ashwini also referred to earlier in her presentation. Regarding the statistics question, I think one reason I think statistical department is not able to disclose the data is because of the capacity, I think, primarily. And they have also admitted that during our interviews with them. The last bit I think I want to respond is interactions of data between the government departments and how efficient has that been. And this is my own personal experience I'll like to share from that perspective. My daughter, who had undergone a vaccination program, had also given, the health department had taken her, blood sample, and we know her, the blood group, definitely. Then we took her to an admission to a school. The school started saying, please submit a fresh, fresh blood group certificate. And, that means I have to go to take my daughter to the hospital again, prick a finger, get another certificate. I mean, kids, it's not easy. If the interactions of data was there between government platforms, the health department already has the data, my daughter's birth group, blood group. So they could have just given it to the education department. It is that simple. You don't need to the government does not need to collect data again and again. So this sort of problem I think we should try to resolve. And this interactions of data, interconnection of data between government departments are not happening efficiently enough. Thank you.
Yeah. Okay. So I think Sri Lanka has put out a contract for a super app is my understanding. So you kind of have started this with about 2 or 3 services, right? So this brings about this issue of, if one government agency can't do it, should we completely decentralize this, right? And one of the findings, our researcher from Thailand is not here, they had a very interesting thing where Thailand has a really good data catalog. That is, they went and list all the data that is actually available. Now, we assume it's complete, but it's actually pretty good. Of course, the actual data is not available, but at least now they can count and say only 10% of the catalog data is available, which is good information, right? And that can be a central place where you then go and search. So Pranesh, I want to come to you to address this idea of, are we better off like everyone hosting their data on their own, on their websites, or there's, pensions department doing their own thing, but it is searchable and there are multiple ways of entering to that location, versus a very centralized approach, which I think India does that. Talk to us about why and why not of the two approaches.
Sure. So there are positives and negatives on both sides. Now, the positive would be no government department has to, control of data doesn't need to be wrested from any government department. They might be, they might have paternal feelings about the data that's in their control. They might want to directly share that and have greater control over it rather than handing it over to a ICT implementation agency. Now the problem is, what we found in India, practically when I saw this happening, was that those in charge of the implementation had to go around, firstly, to get the data. They had to go around from department to department. That is to be expected. No one is just going to hand you data. But apart from going from department to department, they had to do a lot of hand-holding and a lot of technical support and technical work in order to get the data into publishable form. So it's not just a matter of, the alternative in a decentralized fashion would be for each government department to have its own open APIs and so on. Now in a utopia, that'd be great. If they have all their data sorted, they have open APIs so that a single portal, a citizen can go to a single portal, but through that portal gain access to up-to-date information being stored by every government department. That'd be great. But the technical chops for that actually don't exist in many of our countries. It's going to be difficult to implement. Whereas it's far easier to just get technologists to work with a single government department to build out a really efficient system at that level and deal with outdated data and so on in that process. So there's a trade-off. On the one hand, you have outdated data if it's centralized. You have a situation where there's political negotiations if it's centralized. There are all kinds of problems, but decentralized also has its problems. I'll also add one thing that is taking on from what Semanta mentioned. In India, we have a system called DigiLocker. Now, originally, this was supposed to be a completely decentralized system. Now, unfortunately, it's become a government-run thing, and only the government hosts this information. But this is a system where all the information regarding you is in a centralized locker that you control. Different government departments can request access to different kinds of information from that locker, to different data from that locker, including things such as your mark sheet from 12th grade and so on and so forth. And you control access. You can say whether to allow or disallow access. Yeah. So the information is centralized, and different government departments can push the data into this locker. So you don't have to go from different department to department actually begging them to give you this access. They can say here are all the things that we have. You can say, please add it to my locker, and then you can decide which other government department to share it with. So that control, that at least gives the citizen control over data sharing, rather than just requiring rules as to what kind of sensitive data, Department A will share with Department B, but there's another Department C that requires heightened levels of sharing, and so on. Rather than, the government framing all these kinds of rules, it gives it to the citizen to decide. And I might also,
Quickly,
quickly add one more point, which is that Norway is an interesting example where, despite the GDPR, in Norway, citizens' tax records are made publicly available online. They have a long history of making it available at the municipal level. Now it's publicly available. But to access any ordinary citizen, not just politicians, any ordinary citizen's tax records, one, you have to log into a government system with your government ID as a Norwegian. And two, when you access someone else's information, they'll know that you looked at their tax records. And when they access your information, you'll know. So that's a interesting mix of transparency on both sides of both tax records, but also who's accessing your tax records.
Yep.
That's becomes an interesting system.
Yeah, yeah. And unless, does anyone in the audience have questions along this sort of open data, open government, transparency? There's a question at the back. Can we get a mic there? Yes.
Hi, yes. So I gather from the regional perspectives that there's a challenge across the region that governments, for example, aren't quite open to sharing data. I'm just looking from an academic perspective myself. In academia, for example, funders currently have a provide incentives for those receptive researchers to open up their research, not just for publication, but the data. So in other words, if you get a fund from us,
Yes.
you have to just publish, plus you have to put your data out. Is there any evidences across the region, for example, funders, when it comes to funding governments, to give an incentive in that way? Thank you.
I mean, I can just answer on our experience of dealing with UK and Canadian funders. For example, the International Development Research Centre, which is a large development research funder and also sponsored this study. For now, about maybe just pre-COVID or 6-7 years, has had an actual rule about the data sets and not only the data sets, the publications also have to be both open source. In the early days, they would pay for the article to be made open source. Now it is open. And I know they fund science granting councils in multiple countries across the world, and the same rules apply. And depending on the country, they actually can be a significantly large enough funder. Yeah, that's just my input. Anything else? And I know there's another question there.
The central science funder in India actually has a requirement that not for necessarily for data, but at least whatever they fund, that the publications need to be openly accessible. And so the largest science funder has that requirement in India, the governmental funder.
Shakti, Indonesia, anything? Any of the other speakers? No? Yeah?
Perhaps I think not on the government side, but if NGOs are receiving funds in Nepal from outside, those funds and where they have been utilized, because NGOs also fall under the public authority definition under the Nepal's RTI Act, they also need to disclose how these funds have been received and which area these funds were utilized.
The tough part, I would say, is even in multiple countries, open data policies exist. It's the implementation that ends up being. So even if there's a funding that you receive with an open data requirement, or even otherwise there's a governmental policy, who's actually implementing it? Who's checking whether you have published an open data set or not? How are you going to enforce it as the public, that ends up being a big challenge.
And the infrastructure required for that. So we have a sister organization working out of South Africa. I mean, we have a constant problem of our data sets. Somebody has to go search on our, we don't have a partner whose job it is to host this data. Whereas in Africa, University of Cape Town has a data repository that's known, has metadata and searchable. So they just have a partnership with them, and all their data, I mean, it actually gets found way more easily than exactly the same data set that we host on our website. So that infrastructure is as important as the rule, I think.
Just to add what Semanta said, the similar provisions exist in Sri Lanka as well under the Right to Information Act. You're still able to request information because a public authority, as defined under the Right to Information Act, extends to those performing public functions, including universities, educational institutions, non-governmental organizations, etc. So I'm just saying that we have a similar provisions.
Has there ever been an instance of RTI coming in for like a data set from a university?
Not really from a university, we don't, but we do have instances where they've used it against, let's say, the Chartered Institute of Chartered Accountants, asking for information. And then they had, the contention they had raised was they're not a public authority, but then they said, no, you very much are a public authority because of the wide definition of a public authority under the Act.
And there's a question up front.
Yeah,
Rohan.
just a small correction also. I don't think NGOs are public authorities. It's any entity that receives public foreign funding. So if you're an NGO and you receive, that's what brings you in.
Yes,
but if I run an NGO that doesn't take
any foreign funding, no. But the reason why I mentioned an NGO, Prof, just to add to that is because there is a general provision under Section 43, one of the prongs says if you're performing a public function, many times what happens is potentially, we don't have any precedents, but potentially there have been instances where NGOs have voluntarily given information based on the fact that they are performing public functions or public services. That's how they've been brought in. But
the question I was going to ask was on this general question of access. The most interesting database in Sri Lanka, public database in Sri Lanka, is operated under the Assets Declaration Law. So that's the anti-corruption thing that a few mentions were made. But it was interesting that there were two different rules regarding the details. So when the presidential election was conducted, because there is some language which says certain items may be redacted. That is, you have to give, but it need not be disclosed. So, for example, I looked up several candidates and how much money they had. All I knew was that they had bank accounts. The amounts were redacted as long as they were candidates. Then on the second round, somebody had gotten around to giving the actual amounts, right? So my question is, I think that's going to be the most interesting database for many people, including the media and anybody else, I guess. And it's going to be the most vulnerable to cyber attacks. What's the situation now? We used to talk about the Indian asset declaration, every time somebody runs for office, the newspapers would run these stories, this person had this much gold and this much this and whatever. Can you guys compare what's happening in the different countries with regard to asset declarations?
One of the countries, I can't remember which had, I think, if it went over a certain percentage,
The wealth.
Yes, so please, explain this.
Thank you. So Indonesia has a very good precedent where public officials are mandated to declare their wealth or assets, especially when you are under the definition of public officials. And it is conducted every year. And, the level of information is very specific on the persons. So when you are failed to report that, there will be considered as a violation of the law. That's we call it as asset declaration report. So that's also has been around since 2005, I guess. Yeah. So that's one of the learning.
In Pakistan, like many other South Asian countries, our politicians are very poor. They don't have much in their bank accounts or the assets in their name. And that is one of the reasons that it was decided that they need to find those declarations after the election, because before the election, they probably would not have anything. So after elections, they are bound to follow that. But interestingly, a few years back, when the Right of Information came out, 2017, the Federal Board of Revenue, they got so excited that they published every taxpayer's data on their website in a PDF format, searchable, anybody can have access to it, even download it, no problem. And then after some time, they realized that a lot of people who are in the top tier getting ransom calls, because everybody knew how much assets they have, how much money they have. And I was one of those lucky guys who got the call. And then we had to report that, please take this off. This is going to be a much bigger problem. We do not have a data protection law for the time being, so we cannot actually make a request under that. But this is a security situation. This needs to be taken down. So that has been taken down. But now only the government officials and the politicians, they have to submit those declarations. And that is for the sake of transparency and, of course, making sure that they are not making any corruptions afterwards.
So that's a question of a trade-off, right?
Yeah.
And when we are talking about disclosure there, is it exact amounts or is it ranges?
No, it's exact amounts.
Exact amounts are disclosed. Same in India?
Yes, in India, exact amounts are required to be disclosed. Landed property values, everything.
Disclosed to the authority, yes, but disclosed to the public.
Disclosed to the public, including your spouse, so
Yes.
not just your own wealth. And recently, earlier this year, the Supreme Court of India extended this requirement to the Supreme Court justices. Now, not all the justices have complied as of yet. I just quickly checked, but the majority of the justices on the Supreme Court have also declared their assets publicly. Now, of course, there isn't a separate body that is charged with verifying whether the disclosed information is accurate or not, but all the disclosures, at least when it comes for elections, is done on pain of perjury. So if you misdeclare, that is independently an offense under election law.
I'd like to add a bit on Indonesia. Yeah, that's also happened in Indonesia. It's very detailed, and your spouse, and it's regularly reported. But we expand who are mandatory to report. Even the director or the board of director of the state-owned enterprise also mandated to report. So it's not only for the law enforcer or government official, but also for the BOD and BOC of the state-owned enterprise are mandated to report. And it's really detailed. They can locate where your land ownership and house and cars and etc. It's really detailed, and it's been around since 2005.
Yeah.
Can I interject just one point on this? So regarding this wealth declaration and by public officials, the public official could fall under two categories. One are the elected public officials, and other are the general public officials like bureaucrats. So in practice, the bureaucrats just file their wealth declaration just to the authority, that is the Central Vigilance Commission. It is sealed, it is never taken out from the envelope. And only if there is a corruption investigation, the corruption body can request and then compare the wealth for any, amassing wealth disproportionate to the income. I think that could be one way. But with elected public officials, as you said, the elected public officials, the definition could extend even to the parliamentary members. It is also disclosed to the public. So there's a distinction there between elected and non-elected public official.
Yeah. So we've been talking about this idea of transparency, which is really enabled by the public availability of data. The other angle, obviously many people will talk about why we need data is so that private sector also and civil society can innovate, right? Use data, build apps based on government data. But then today, like when we were talking over coffee, it might be related to transparency, but it's about this data ecosystem and making it better. The example you brought, I'd really like you to talk about it, which is sort of the government puts out data and then the feedback mechanism from that happened, like in India, I think.
So There are multiple examples in India and outside India of where open data is really either improved or generated by civil society actors or by companies and made available to everyone. So one example is in India, there are different kinds of administrative divisions. Some different one for tax, different one for other kinds of administration and so on. There's information that's required often at the level of villages. Some of this information is publicly available in geographic formats called shapefiles. So you know the boundaries on a map. Now, in multiple situations in India, one, the shapefiles that have been put out by government departments have been found to be incorrect. And so those corrected versions have been hosted by a group called DataMeet, publicly on GitHub. And so they've taken what the government has put out, improved it, and made it available again to the government and to anyone else who wishes to use it. In other cases, actually creating something from scratch. So before the government had ever published bus route information, a friend of mine who used to live in Chennai, he, back in 2009, he created open data and made it available on his website. At that time, he booked busroutes.in and made that available. And he'd also designed a really nice bus route information for the transport authority in Chennai to actually use, which would display, he's a design student and it came out beautifully, except they didn't end up using it because he didn't know who to contact. He went multiple times to try and meet officials. No one was interested, and we're still stuck in the dark ages on that front. But now the government, the transport authority in Chennai, they make that information publicly available as well. Though there are some problems, but now entities like Google Maps incorporate that information. So no one needs to go hunt down some obscure government website or find an obscure government-made app. The government doesn't need to make those apps available either. Just by publishing the information, they make it easy for anyone with any kind of interest, whether civic-minded or profit-minded, to actually use that and create benefits for citizens and consumers. That's the beauty of this. So one, it benefits consumers and citizens without the government having to do very much. And two, it improves the very data and in some cases generates new kinds of things that the government itself can use thanks to the magic of essentially open source as a concept where people can improve. Now, for all of this to work, it has to be open data. What the government publishes needs to, A, not be copyrighted by the government. And there are some very silly cases in India where the railways are trying to enforce their copyright over railway timetables. It's silly. It's absolutely silly, except they're still trying to do it. It makes zero sense for the public to not have access in a myriad of ways that they can easily consume railway timetables. It's not some highly proprietary secret database that they're seeking control over. But apart from that, sorry, I lost my chain of thought. but one is that governments themselves need to do very little, and they get back a whole lot, and the public benefits. This is a win-win situation in most cases. The concerns are, and let me also add, the concerns around privacy, around proprietary information, those can be tackled because this isn't an all or nothing. In India, for instance, the policy that the central government has published for central government data has multiple categories. Stuff that is completely open, stuff that is mostly open, and two other categories in the middle, and stuff that shouldn't be opened. Every government department has to categorize their data first. And after they go through that process, and the basis for those decisions also have been provided in the policy as to what considerations drive this decision. After they go through that process, what's fully open has to be made public. And what's mostly open can be made public, but requiring things like reasons in order to gain access. So it's not, and in some cases, non-commercial access may be put. So it's not an all or nothing, but in most cases, you're going to derive maximum benefit by making it fully open, including for commercial access, but that's not a requirement.
Yeah. And is commercial access to government data a bad thing? Because some people argue this. I mean, I certainly don't believe this, but are there mechanisms of benefits flowing back other than the data quality improving and the whole data ecosystem improving?
That should be reason enough.
Yeah, exactly.
I'd say.
Yeah.
Now, there are different examples from different parts of the world where, so in the UK, which was one of the first to really adopt open data, you see all kinds of benefits, such as where people using one, through just any source, through any railway company, I can plan a whole trip despite there being multiple private operators and a government operator of railways. I can plan out a whole trip through any of the apps. They all interconnect like magic. So I don't need to worry about, oh, this is this company and so I have to book the different legs differently. No, it just works like magic. So things like that won't be possible if there are no interoperability, if there are impediments to interoperability. The second is sorry, I lost my chain of thought.
That's okay. I was just asking about financial flows because government seems to be obsessed about cost recovery, as are international organizations when they put out their data sets.
Exactly. The other thing I'll add is, in many cases, the government needs to invest less. So they are to see it as a saving because they don't need to invest in that app to make it actually accessible to the public. They don't need to invest in additional cleanup of data and so on, as long as it's legible, as long as, other people will work on it and improve things. So it requires less investment by the government. And there's another example more around copyright that I can provide if we have time.
We'll come back to that, yeah? Want to move on to, actually, just a quick question. Who should run data.gov.lk, Ashwini?
So I'm going to just give a short and a little bit long answer. The short answer is currently data.gov.lk was pioneered by Prof, who's amidst us, and with the ICTA being at the forefront. And before, yes, so that was an initiative that was pioneered by ICTA. I do think that we need a central body so that we get data sets from these various departments. So it can be, ICTA can continue to do it, or because ICTA now is in sort of a structural, existential crisis kind of a thing, so perhaps it can be the Ministry of Digital Economy, because they're always about making sure that open data is available across different departments. So I do think that that is one potential to make sure that that's the body through which we have data from across different departments.
Thank you. Yeah, quick one, Aslam.
Yeah. On the commercial use of data, I think there's one example where the survey of Pakistan, which has got all the maps in the age of Google Maps, they say that you cannot sell it. You can just have a copy if you're a Pakistani citizen. If you're not a Pakistani citizen, you cannot even have access to it. But even if you got it, you cannot resell it. You cannot use it for commercial purposes.
Okay, thanks. The next issue is very emotive, particularly, certainly for civil society organizations at international events. Everyone wants something called data sovereignty, usually defined as a government having access to its own data when they want it, also defined as somehow, therefore, being the data being hosted within the geographic jurisdictional boundary of this same country, of this same government, okay? Indonesia, we had a whole event last month where that was the focus of the discussion based on our studies, but that's what it was. What are the justifications people give and have given in Indonesia for this idea of localization data? And by the way, data localization has multiple forms, right? Some countries say everything is kept in the country cannot leave. Other countries have said you keep a copy in the country, you can take a copy out, and so on. Other countries have said certain data can go, certain out, etc. Right? So talk to us about India. What is the justification in this policy debate for wanting data localization?
Yeah.
Thanks.
Yeah, thank you. Indonesia is a big supporter of data localizations because of coming from the discussion with the regulatory sectoral regulators, where they believe that there are very a unique reason why they have to keep and restore the data within the jurisdictions. But there are always 4 reasons why data localization is something that they fight for. First, that they believe that it is easier for regulatory oversight and audits to have the access of data while when the data is within your jurisdictions. And the second argumentation is that they believe on, like it's to protect national security by limiting foreign access. But that's really against the practice of nowadays business and data use in Indonesia. And the third reasons coming from the law enforcement point of view, that the law enforcement point of view, I believe we had that discussion during the session in Jakarta, that it's easier to, to have the data center in Indonesia to, to find and to get the evidences when there is a criminal cases regarding the data. And the last argumentation is coming from the economic point of view. The government tried to encourage a local data company to be in Indonesia. That's why they always invite, like the big investor to have their data center in Indonesia. But it's really the 4 argumentation why data localization is still on the discussions, and it's really difficult to move the needle for the government point of view.
And in Pakistan, you went there with a draft piece of paper, also kind of with wordings around industrial policy, because it's going to bring in a lot of investment to set up data centers, localization. That was one of the justifications. And I think you were involved in arguing against it. And what's the status and what are the arguments in Pakistan that were made to show that that's maybe not a good idea?
Well, in Pakistan, with this data protection law, which is a draft, they propose that there's 3 categories of data. One is, of course, the individual's data, which is fine, it can go out of Pakistan. Then you have got sensitive data where you need express and certain conditions and express consent. But then they said the 3rd category is the government's own data, and we will not let it go because it has national security implications. We do not want this data to be subject to the laws of any other country. And 3rd was because they also came up with this cloud first policy. They said that if we keep the data within the country, there will be these big players who would come and invest on data centers in Pakistan so that we can have the data within the country. So, I mean, it's strange arguments. And then LIRNEasia went in and we actually explained it to the government that data localization is a bad idea, and then certain implications including the talent and investment and all this stuff. And of course the security of the data itself, because we have seen the data which reside in Pakistan within the government control has been leaked multiple times. And sometimes it's on sale for just 500 rupees. So in that environment, you need to have the kind of capacity which is not there. So far, they have backtracked. It's not coming up with this clause, but you never know because they have not said that they're going to drop it. This probably. The other challenge is that other than this data protection draft, bill draft, there is another set of localization requirements coming from the sector regulators. And those regulators, for example, on the financial side, the State Bank, and then you have got the telecom sector regulators, they are saying that nothing doing, no data is going out of Pakistan. It has to be within the country, whether the users are giving consent or not. And even to the extent that the central bank said that the data has to be within the premises of the banks and its own cloud and not a third-party cloud. Yeah. So I don't know whether after this data protection law comes in, these stricter requirements would continue or not, but this is what it is for the time being.
What are the thoughts around sort of there is data protection laws and sort of adequacy requirements? Maybe you can just talk a little bit to the audience what that actually means who might not be familiar with it. And how do we feel about some sectors having even stricter things? Everyone seems to say, oh, well, it's even better for protection and therefore that sector can do in harder things, right? What are the thoughts?
Sure. So first, we look at the cross-border data transfers under the Personal Data Protection Act, under the PDPA. So we first had a requirement under the Section 26 of the PDPA stating that if public authorities wanted to transfer data outside of the country, they needed to have an adequacy decision, and the minister would publish the list of matters that can be stored outside, and when there is an adequacy decision, it can be transferred to that country. Now, for those of you who may not be familiar, in very simple terms, adequacy decision is a decision it's been imported from what the EU GDPR required, where they would state that if data has to be transferred outside of the border, so if data needs to be transferred outside of Sri Lanka, it should be transferred to another country where the laws are adequate to the protections that's being offered in Sri Lanka, so that the Sri Lankan citizens and those whose data is being transferred will not be adversely affected. So in simple terms, that is an adequacy decision. Now that was what was existing in Sri Lanka. That's no longer the case because we have the amendments, and that amendment has removed the requirement of adequacy decision. So it doesn't exist for public authorities, it doesn't exist for private authorities. So now you can transfer data without an adequacy decision, but that does not mean that there are no protections. We have what we refer to as appropriate safeguards. It can be in terms of contractual safeguards that will ensure that the same protections that would be given to citizens' data, personal data in the country will be given elsewhere as well. So we do have appropriate safeguards that are in Sri Lanka under the Personal Data Protection Act, which would mean then we can transfer citizen or any personal data outside the borders of Sri Lanka, provided it complies with the requirements under the Section 26 of the Act without having to consider a adequacy decision. Because an adequacy decision is not very simple, and I know a study that was done by LIRNEasia actually highlighted the fact that how very few countries have an adequacy decision, and if we look at the Global South as just one example, so from Argentina. So it may seem simple, but it's actually not very simple. So we welcome personally that move to bring that amendment. Now, having said that, the second part of your question was about sectoral requirements. So I'm going to take an example of Central Bank of Sri Lanka, where there are important compliance requirements for banks, both banks as well as non-banking financial institutions, through technology risk resilient framework. And under the technology risk resilience framework, there are requirements. It's not technically data localization. They do not say that the data has to be stored in Sri Lanka. They never say that. But there are requirements in terms of legal access, as we would call. So there should be agreements that ensure that if there is an order by the Sri Lankan judiciary, there should be compliance by that country through the order. And it's done through contractual safeguards. So the next then question that you may think is, would these entities across borders be agreeable to these terms? And we still don't have too many examples of how maybe an Oracle or a Amazon cloud service provider is agreeable to terms like these within their contractual safeguards, but these exist when it comes to sectoral requirements.
Yeah. And I mean, I want to come to you, Pranesh, a lot of these sort of disagreements where we would point out this silliness of, legal access is what you actually need, your data is as secure somewhere else kind of thing. The other side used a lot of the American actions of snooping to say, oh, well, not really. I mean, look at what the US is doing, right? But there's this sort of nuances we need in this conversation about legal access, what the hackers can do, which is illegal access, and what then each of those means for where the data is hosted. Said that how should we think about this?
In India, we've had data localization requirements for a very long time, from at least the mid or early 2000s for things like telecom data, and wide variety. Through the 2010s, it's only increased. Now India is one of the countries with the largest number of data localization requirements from different sectors. And the data protection law, which still hasn't come into force really in India, that does not have a data localization requirement as it was passed. But things to keep in mind. One, for countries where there is no strong data protection law, might actually be protected better. Your citizens' privacy might be protected better in third-party countries where they actually have stronger data protection laws than yours. So that's one thing, because data processing is what gets data protection requirements kicked off, regardless of whether the person whose data is being processed is a citizen of your country or not. So that's one point. And California, where a lot of the data is being processed, has a strong data protection law, CCPA, that was passed a few years ago. Second, if you want to hold someone who violates your laws abroad, okay, so does the data processing abroad, but it's your citizens' data, then whether the data is located within Sri Lanka or not, or within India or not, does not make any difference. You hold the people who are violating the law or who passed on the information in the first place, you hold them liable. It's what legal protections you have in your country that make the difference as to whether it can be prosecuted or not. It does not matter whether it's being processed physically in a data center here or elsewhere. That has absolutely no bearing on the legal question as to whether you can prosecute or not. Now, when it comes to security, you can say data leaks will happen and can happen regardless of where your data is being stored. You can have the strongest data security requirements in one country, and yet data can be leaked if it's not being handled properly. And this happens regardless of which country it's located in. India has had thousands of data leaks and data breaches, despite having data localization requirements. So security, can't be that kind of reason. Preventing data breaches can't be a reason for data localization. Okay, let's go further. Protecting your data from international actors. I can say India, during the Snowden leaks, it was revealed that after Afghanistan and Pakistan, India had, all these three countries had the highest number of telecom surveillance being conducted by the NSA. So this one tool, Bandler's informant, gave access to call data records. Now, within 1 month, billions of data points of Indian phone call data points were captured by this one tool. Billions in just the month of February 2011 or 2012, I think it was. Now, clearly, that the requirement of data localization that had been present in Indian telecom licenses did not prevent the NSA from gaining access to that data. So it does not matter, and in fact, it might have made it easier with telecom companies not doing as good a job in India as they might have elsewhere. Now, lastly, let's look at using data localization requirements as an incentive for data centers. There, the biggest impediment is it's costlier to host data locally. Why is it costlier? Well, because many of the good things that they have in first world countries, we don't have in our countries. So in India, one of the largest costs for telecom provision in India is the cost of diesel, because diesel is required to run generators because electricity provision is not fully reliable. So again, data centers, they need 100% electricity. And these electronic equipment, you can't have even a microsecond of downtime, right? So uninterrupted electricity supply becomes a big issue, which we don't guarantee in our countries. Secondly, so if we provided electricity that was fantastic without being interrupted all the time, then data centers would have it easier. Secondly, the cost of just transporting data, network costs are higher in many of our countries than outside. So in India, until a few years ago, and even now in some cases due to bad networking, but until a few years ago, it was actually a lot of data to be transferred from Delhi to Chennai would go outside of India and come back into India because that was cheaper. Now, it's only recently by increasing the number of what are called IXPs, Internet Exchange Points and so on, by making networking cheaper, that you allow much more of your data to remain within the country because because it's cheap to transfer from one place to another. So making it easier to run data centers isn't a matter of legislating. And even if you legislate, the cost problems aren't going to go away. It's going to be incredibly costly to run data centers in your country. So so making it easier to run data centers is the answer there. The only argument for data localization that holds water is when it comes to local law enforcement access to data. Now, in most of those kinds of situations, the local authorities are not asking for the kind of data that most data localization requirements actually deal with. The kind of data that they're generally asking for is communication data, private communication data. But imagine, would you be willing as a policymaker to say that all email communications, all chat communications, and let's remember even your ride-sharing app has chat facility, that all communications of any kind must remain within your country? Now, that won't even be feasible because people won't be allowed to communicate with people outside your country. So communication, if it's international, data has to leave from your country and go to some other country. So you can't actually enforce anything of that kind. So, and requiring any communication provider of all kind to set up office here in your own country, in India, in Sri Lanka, is just infeasible. It just can't happen. So but that's a real genuine problem. Most of our countries a lot of our data is with companies based in the US, and law enforcement agencies have difficulty accessing that in very many genuine cases as well. Things like mutual legal assistance treaties are normally the way that they go about doing this. There's very slow progress right now. There's a new cyber crime law that's been, or treaty that's been passed at the UN level that might alleviate this problem a little bit, but that's a different problem. That data localization might actually help, but unfortunately it's too difficult to actually implement data localization in that situation.
But that's not even the only time when governments are talking data like localization, and that's the problem, right?
In all the other situations as I went through, for privacy, for security, for local incentives for data centers, I don't think the arguments for data localization hold at all. My sympathies lie with the only situation where I think there's a legitimate benefit of data localization is when law enforcement agencies need access to confidential data that is being held by, in most cases, it's about communications data. And that's the only place where I think it's a legitimate.
Aslam, you wanted to come in, and then we'll go to Trinesh, and who else had a question? There's a question at the back. Just give us 1 minute, and then we'll come to you, and then Trinesh next, yeah?
I think in addition to what Pranesh was saying, competence and other issues, I think one of the problems which has been identified recently was that the awareness about securing data doesn't also exist. In the friendly exchange of drones between India and Pakistan in May this year, both sides tried to test websites and portals of the other countries, and then we found out, interestingly, that username password admin and admin1234 is not a good password. And the reason, obviously, was to help each other to improve our portals. And then we saw that almost half of the portals on both sides were down simply because admin and admin123. So I think the awareness, the competence, and of course the realization that they need to spend money on these things, which they don't have. In Pakistan, again, when we are having discussion afterwards that how to secure those portals, and one that we didn't have the kind of people who can protect us against the attacks from Mr. Snowden's country, because nobody has got budget for that. And then the people who could actually secure those portals, that was also not there. So I think awareness is also an issue, and competence, of course, is there.
Thank you. So it's obviously not just the policy. There's a whole other set of compliments that need to come in. I want to take the question from at the back of the room. The lady, yes.
Hi, thank you very much for giving me this opportunity, and it's a fantastic dialogue, and I really appreciate it. My name is Rangita, and formerly I was working for the Embassy of Switzerland. I was working as a Federal Department of Foreign Affairs of Switzerland. So I just wanted to share one of the insights, because you also mentioned about Switzerland before. So in Switzerland, as one person also asked about the data and the accessibility of it. So I was heading the Sri Lanka bilateral funds at the embassy. So let's say, for example, when we fund a country with some development funds, they have a very fantastic archives department in Bern. So let's say, for example, if you're a Swiss citizen, you have all the eligibility and accessibility. Let's say even you don't have a house in Switzerland because you're poor, but then still, you still have the ability of walking into this National Archives, and let's say you ask them, I want to find what happened to my tax money that had been invested in this particular project in Ghana in 1998. Still, they will have documented records in paper form. Now, the thing is that when we are, so I must also tell you, still they use Skype for business in communicating, not because they don't have money to invest in other technologies, but now only actually they are going with their digital archives, digital ones, but usually what they use is paper-based. What I have seen a difference with the world here is that they have a thing called data discipline, which has been taught to them as a young child. So even if it is like, they don't have like super sophisticated systems, but they have a thing called data discipline, where they know exactly with whom they should be sharing information, where to store it, and also their trainings and development on data archiving is very specific and very diligently done, even their integrity systems. Now, just adding to Ashwini's one point about this jurisdiction point. Now you will understand why people are saving money in Swiss banks. Because this is why people cannot actually access to information out from the outskirts of the borders. So just wanted to add this point. Also adds to the first question that was asked before on funding. Thank you so much.
Thank you. So I think this idea that it's sort of not just the law, this ecosystem, all of that. I mean, on the Swiss bank thing, I find it quite interesting because, I mean, if you're powerful enough like the US, you break the Swiss system, right? And you have to declare. So it's also a power relationship there as well. Trinesh, thank you very much for that intervention.
Thank you. Pranesh, that data localization question, isn't it also a concern that the party who's actually keeping that data will be taking it? That's a concern.
Meaning like the web services host kind of thing, the
Yes.
contractual.
So,
yeah?
so in US, the law enforcement will actually ask for it and take it. And that's the, I think the initial concern which gave rise to the Cloud Act, where law enforcement asked Microsoft to give offshore data, and they didn't, and they went to Supreme Court. And as a settlement of that case, Cloud Act was born. So the fear now, India, BlackBerry, they asked to localize. Saudi Arabia, I think, asked to localize, not to keep in Canada. So similarly, I think all your other things are agreed. One question is that the place where it's kept, and that those law enforcement guys will actually ask for it.
So my answer to that is twofold. One, the protection under the Fourth Amendment, the protection that US law provides for my data, or Swiss law provides, or other laws provide to my data, is higher in those countries than in India. So it's tougher for US agencies to get legal access. Forget about the legal access for now. Forget about the NSA and so on. For law enforcement agencies to get legal access to my data. Forget about the some of the kinds of powers that the FBI has in extraordinary situations. But regular, law, regular police department will have a tougher time gaining access to data, to my data, if it's stored in the US, than if it's stored in India. So one. So from my perspective, as a citizen who's concerned about privacy and who's concerned about access to my data, it might even be better to locate it outside of my own jurisdiction. Second, with BlackBerry, with other kinds of things, when it was located in India, that doesn't necessarily help, because with encryption, it doesn't matter whether it's physically stored in your data centers in your jurisdiction. If you're not able to break that encryption with, and the kinds of encryption we have right now, even the NSA is unable to break them in most situations. Tor encryption they haven't broken. A lot of stuff that they store in Utah, in their data centers in Utah, is for the future. That is, in case in the future we are able to break the encryption of today, they still store a lot of data for that purpose. But encrypted data, if you can't break, and if it's end-to-end encrypted and the service provider themselves don't have access to data, it's not really helpful where the data is located. So for regular data access, where it is not end-to-end encrypted, where there's a plain text copy or at least metadata around that, which is located in a foreign country, which your country's law enforcement needs access to, from that perspective, I think, at least speaking for India, maybe the legal standards are much better in Sri Lanka. Citizens' privacy is upheld much better. I don't know, but at least as a citizen of India, I can say that this one situation of law enforcement needing access is the only situation I can contemplate where it would actually be beneficial to have data locally in India and not outside, because it takes many months often to go through the MLAT process, quite unfortunately, and that's helpful in solving crimes and solving regular crimes, not terrorism and this and that, just regular crimes, and that's my one point.
Any other questions? Semanta?
Yes, this is a very simple, very general point that has come across my mind when talking about data localization. And this is from the perspective of physical security, not really cyber security or cyber threats, but physical threats. This is our experience that we had in Nepal recently. So during the Gen Z's agitation amongst the different government bodies which were attacked and set to fire, the Supreme Court was also set to fire. The data center at Supreme Court was set in fire. So whatever data was there at the Supreme Court, like we lost all the data from the data center. Fortunately, 100 kilometers away, there was a data recovery center. And I think the agitators did try to attack the data recovery center in that location also, but the security officers were able to fend off that attack. From my perspective, if that data recovery center was also set to fire, then Supreme Court would have lost all the data. So from a physical security standpoint, maybe perhaps, if the data center or recovery of the data center was located perhaps outside Nepal, maybe that's an advantage sometimes. So from a very physical security standpoint, I'm trying to make that point.
Yeah, very true. Thank you. Yeah, quick one then, and we have another question.
Yeah, so 2007, cyber attack on Estonia databases, and the data embassy concept coming in to Luxembourg. So that's a novel way of, I think they earn money off that. And a country where 99% services on internet, except marriage contract and notarial property transfers, not able to do online. Everything else you can do. So it's another concept. So data governance, just to add to that. And Pranesh, that point earlier, remember that Apple was asked to give access backdoor. Actually, Uncle Sam got access backdoor. Did you see that? Sorry, I see in this, I've read about this, that they said cannot because encryption, but the government or FBI actually opened it up. And
so what happened in that case? The FBI was originally, so this is about the San Bernardino terrorist attack where a couple blew themselves up and so on. But initially the FBI could not gain access to the Apple iPhone of one of the attackers, because Apple had a system where if you try multiple times, then it's possible if a particular setting was turned on, then the device would get wiped out. Now, the FBI didn't know whether that setting was turned on or not. Externally, it's not. They weren't able to figure out. There's no way of figuring out. So they can't try multiple passwords to try and break it. And they asked Apple not to just break the code, but to create a special image of the operating system, which would allow them to bypass the phone's encryption and so on. Eventually, Apple went to court, refused to do that, saying it violates our free speech rights, brought in free speech protections here. An Israeli company managed to find a flaw in Apple's encryption, in how they had implemented that encryption, which Apple has since fixed. So that same flaw is now not usable again. But there was a flaw, there was a security flaw in how encryption had been implemented. It wasn't that they could just overcome the encryption, but in the software implementation there was a flaw, and hence they could bypass the encryption, and which has since been fixed by Apple. There are all these security flaws all the time, but that doesn't mean end-to-end encryption is easily defeasible by law enforcement agencies.
That piece of information which actually the Israel company broke came through a RTI request to FBI about a payment that may had made to a company, and there's a RTI request. That's my read.
Okay. Even sort of seriously data-hungry algorithms and the researchers in the field don't buy into this idea of, centralization or particular jurisdictions are important. Fields of research on federated data, for example, where you can run very sophisticated models with methods of sampling, leaving the data in, very different places. So, yeah. Anyway, you had a question, the gentleman up here.
Hi, good evening. I'm Chandra from Ministry of Finance. So
Yes.
I have a question to Ashwini. So you said earlier that there is a section in the PDPA like that data you can store outside of the Sri Lanka. So
yeah, sure.
can you bit more?
Sure, I can elaborate on that. What I was trying to explain was what was the erstwhile Section 26 before the amendment and after the amendment. So if you see Section 26, it's the section on cross-border transfer of data. What the section previously was, before the amendment, was that any authority, it can be public or it can be private authority as well, as is defined under the Act. So Ministry of Finance obviously is a public authority. Anyone can transfer data provided there is an adequacy decision. But this was mandated only for public authorities. For private authorities, if you have an adequacy decision, well and good, proceed with the transfer. But even if you don't have that, if you have appropriate contractual safeguards, you can transfer data. So that was the section that existed prior to the amendment. Previously we had that. But now we have an amendment, and this amendment was passed on the 30th of October 2025. And based on this amendment, you no longer need an adequacy decision to transfer data. I just wanted to emphasize on the point that just because there is no adequacy decision, it doesn't mean that you have a free hand, you can transfer data wherever you want. You still have to comply with the requirements of Section 26. The requirements are twofold, in the sense, number one, either you can say that it complies with all the requirements of Section 20, 21, 22, all of those section requirements are fulfilled, or you can say that you have appropriate contractual safeguards, and there is also a basis for processing of the data. So for example, let's assume you are relying on consent. For cross-border transfer of data, it's explicit consent, or it could be necessary for performance of a contract, it could be legitimate interest, all of that remain. It's just that the requirement of an adequacy decision has been removed. And an adequacy decision, what I mentioned earlier, was that it's not very easy to come up with an adequacy decision because it requires a huge administrative and state machinery to work to come up with an adequacy decision. And just because there is an adequacy decision requirement, which is based on the EU GDPR model, the General Data Protection Model, it doesn't mean that our systems will be very easy for us to transfer data to the EU, because the EU adequacy decision anyway is an extremely difficult one to obtain. And in the global south, we only have one example from Argentina, which has obtained that. So that was the justification for having an adequacy decision. And we no longer need that adequacy decision because of the amendment. So you can transfer data, but it doesn't mean that it's freely transferable. It doesn't say just go ahead and transfer, but where there is personal data, you want to transfer personal data, you have to comply with the contractual safeguards. That is what Section 26 says.
Okay, understood. Thank you. And one other question from, I think, Aslam. So you said that there was these ransoms coming in after the asset declarations. So the thing is, like, I'm on a project funded by World Bank. So there we are on the electronic government procurements. So our aim is to make the data available after the ODs happen. So what I was nightmares, what would happen if those awarded procurement data will access to the public?
You know, the concern was about the identifiable data, which was particular to any person. So it was a personal data where the problem was, and since we didn't have the privacy law and the data protection law, even still we don't have it. And because of that, they just thought it's publish it for the sake of transparency. So it was not a good idea. You are in the same field, so you should not do it. But if there is a requirement of publication, then you can actually do the anonymized data, and doesn't need to be personally identifiable. And since you already have this data protection law, there would be restrictions on publication of personally identifiable data.
So that's a very interesting point, because we do have the Prof had mentioned earlier about the assets declaration under the Anti-Corruption Act. Now there's going to be a database that's currently being worked out with another think tank in Sri Lanka to publish this information. As Prof rightly mentioned, you already have requirements under the asset declaration where you have to redact some information. Now that's just base level, right? And this law was passed in 2023. And it's an overriding one. It says that it also has the overriding provision. But even without that, even if you just remove those redacted, take out all those redacted information, because there is a Personal Data Protection Act now in force, what we understand is more amount of information might have to be removed if it doesn't pass through the muster of public interest related publication. There's not a full exemption that can be obtained for something like asset declaration because we don't yet have any such regulations or guidelines. Perhaps there might be something where you can publish. But the point that was made here on the Pakistan issue relating to right to information as well as publication of information like tax records, etc. I do think there is a serious conflict even in the context of Sri Lanka. We'll have to see how that works out. But as it stands, what we see is, for instance, a reactive request on salary details consistently being asked to be published by the Right to Information Commission. But we do have government policies that indicate that those are confidential information. So once the Personal Data Protection Act comes into force, it's going to be implemented in 6 months. How will that be then considered is something that we still don't know the answer to. It's still a gray area, potentially.
Shakti?
So one last question. Is it okay?
Okay, sure.
So
Let Sakti come in and then you can have your last question.
Okay. Just learning from Indonesia about e-procurement that you just mentioned. So in 2018, the government started the Indonesia Digital Project. So basically, one of the earliest topic that we discussed in this dialogue, that the discussion of centralizing data or centralizing the data or decentralizing data has been responded a bit different in Indonesia because like all the government agencies, they have a lot of data point that they produce and all the report and etc. Indonesia, they established the PMO team under the GovTech project that they call as Indonesia Digital. They started 2 flagship projects. One of them is the e-procurement. Why? Because the 50% of national budget spending coming from the public procurement. That's that learning in Indonesia from the first time you registered as the bidder of the project, people have access to read all the profile and how you approach for the project, and also that's even starting from the beginning of the process of the procurement, and no secrecy on that. So everyone has the access who join and participate as the bidder for the project. And the second highlight of the e-procurement project is also when you are selected as the winner of the project, everyone has the detailed access whether this is the original pricing, and then how like the interaction between the government, the procurement agencies and the winner. For example, there is a negotiation on the pricing and the quality of the product. It's also been reflected on the report. So now, if you want to try, you can access to the specific project, and you will have all the information or all the documentation, the proposal and the result from the selectors.
And does that transparency level also extend to individual consultants who are procured for government services as well, by name? Okay.
Yeah, by name. Yeah, that's a level of details that you will have all the information there.
Okay. You had one more question.
Yeah,
yes.
Understood. So other question I have is we were approached by few CSOs on they were wanting to do the OCDS and open contracting partnership. So what are your thoughts on that according to these data governance concepts and everything?
No, I wasn't going to answer that, but I don't know if we've looked at open contracting, but the principle would be the standardization argument and what that does to data transparency, comparability, and aggregating up and sort of granulating down.
So with open contracting, one, there's the standard stuff which isn't data related, which is just transparency oriented, and which includes things like what level of information you need to publish, metadata that needs to be associated. That's not really data governance. When it comes to data governance, the broad principles would be whatever you implement, use open source software. Now, in many cases, software is already available. Open source software is already available, so you don't need to develop as a government agency open source software just for this. You just need to adapt software that is already in use elsewhere. And whatever adaptations you make, publish it, because there are multiple departments within one's government that require access to similar software. And so if it is public, if it's easily available, even if not publicly to the world, but there is no harm in making it publicly available. A lot of US government departments make their code publicly available, code.gov, which I'd mentioned earlier, right? But even if that isn't made, at least in a private repository, code repository, it should be made available. Second, open source also helps ensure that what you're using is an open standard. If anyone can implement something in open source, then that is an open standard, because you don't need to pay royalties for it. So the standard for any kind of contracting information should be an open standard, so that you get all the required data in a standard process and can use software that someone else has implemented, which has implemented that standard. And lastly, this also helps in publishing things as open data. So most of what we've covered already as general principles, open standards, implemented in open source, with data resulting from it being published as open data without copyright restrictions and so on, without restrictions on commercialization and so on, allowing for greater transparency. All of these principles still apply regardless of what area it is.
I want to come to the last section, which is to get into this conversation around data protection, which is hailed as a very good thing by very many people. We are much more nuanced about the difficulties of implementing it, certainly in this audience and our conversations. But what about sort of feeding the data beast? Like the AI beast has to be fed with data. And not all data protection laws are alike, but many are now being modeled on the EU GDPR principles. Now, there might be other models. Sri Lanka has certainly gone that way. Can we actually have the kind of AI-driven, data-driven future that certainly the Sri Lankan government talks about, in light of having a soon-to-be implemented Data Protection Act? Could we talk about where the conflicts arise very specifically, maybe on a principal basis, and then how does Sri Lanka and the other countries deal with it? I can direct it maybe at Ashwini, yeah?
Sure. So if you see the Sri Lankan data protection legislation, you will note that, of course, there are several legal bases for processing data, and one amongst that is legitimate interests. And typically, it could be interpreted that for the businesses, they could use legitimate interests as the basis to process all of this data that's available online. So we're talking about like web scraping of data, which could include and which would include a lot of personal data. So there are 2 points that I'd like to make here. One is on the grounds of legitimate interests, and the other one is for publicly available data. Now, I'll talk about the Sri Lanka legislation. It does not have any exception just because it's publicly available data. Even if it is publicly available data, where there is personal data that's involved, it will be included, it will be encompassed within the provisions of the Act. So yes, now we do know that all of that data is within the ambit of the data protection legislation. The question is, can it be processed under legitimate interests? And the answer would be potentially yes, they can look at processing under legitimate interests. But that in itself is not going to solve the problem, because under Schedule 5, there is a requirement to publish certain information or give information to the data subjects, where information has been collected outside of direct interaction. Now, legitimate entrance is not a direct interaction, it's not consent-based, so you will have to look at Schedule 5, particularly items 5 and 6. So in that respect, to go and to give all this information to every individual whose data has been collected, including details relating to where it was taken, etc., can of course be disproportionate effort. Yeah. And you might think that that's not workable, which is why item 6 is relevant. And in my opinion, at least, item 6 specifically says that you do not have to give this information to each and every individual, provided you're able to show that there is disproportionate interest. But the only downside to that provision is they have specifically mentioned some instances. They have said it can be for archiving purposes, it can be for perhaps scientific, historical research, etc. Now, of course, AI-related processing is not one of those stated objectives, but since the exception is quite widely worded, I do believe that it can be brought within that, and even without giving all this information to each of these individuals, you're still able to use that data for training.
So for example, we were recently in one of our journal clubs reading a paper where some accelerometer app was installed, and that data was used to look at road roughness, yeah? Okay. And to calculate the value of actually the productivity loss, and therefore the value of keeping the roads repaired, right? So that data could have been accelerometer data is just collected, right? It's used for different purposes. When somebody falls, the accelerometer can warn on health. When it goes over a pothole, it can do something else. Similarly, Joshua Blumenstock has done policy-level interventions during COVID to identify where the poorest and most deserving people in East Africa live and what has happened to them during COVID, and governments have actually identified households that are poor and given subsidies. That saved people's lives. So can we do that kind of thing? If, let's say, our telecom operators are giving our telecom transaction data completely, we'll come to the anonymized, pseudonymized thing, but okay, data, let's say, anonymized in some way, and we are using it at aggregate. The purpose was, my data was created to make phone calls and browse the internet, but now there is a real use for that. Is that allowed? And the real use is actually saving lives, because we might be able to identify a Samurdhivardi household, for example.
And I completely agree with you. So we do have this purpose limitation because it is a requirement as one of the obligations when it comes to protection of personal data. But if we go with your example and we state that there is significant public interest in processing that data outside of the stated purposes, I do believe that we can rely on the public interest exception that's also enshrined within the very same provision that says that if there is public interest, you're able to use that data. So I'm going to stress on the fact that if we do know that there is public interest and that processing is for public interest, going beyond the stated purpose should be all right. It's my interpretation based on the wording of the legislation. But of course, whether it is public interest is a discussion we can have it for another day. But in your example, I do believe it is public interest and it should pass muster under the law.
Okay. So how are these exceptions to privacy handled in data protection laws, or the ones that are at least being discussed in many of the countries? Semanta or Pranesh? Sakti too, if you have.
Make a quick point there. With regard to processing of data, I think in different legislation like Sri Lanka and even GDPR talks about public interest. The right to privacy law that Nepal has passed does not contain any public interest exception clause. As of now, the data protection policy that the government just released for consultation also does not contain any legitimate purpose and public interest provision.
I know we've looked at the Philippines, for example, Pranesh, and we don't have the researcher there, but can you talk about how other countries deal with it?
Sure, but can I first talk about how India deals with this, or is going to deal with it, which is very, very, very poorly. Now, in India, the stated objective since around 2018 was not to just blindly copy the GDPR. And I thought that was laudable, that was great. We wanted a law that was better suited. One of the ways in which it would be better suited would be to not be as strict as the GDPR. Again, a laudable goal. Except where we ended up in the final law that got passed without much discussion and debate in Parliament, because the government did not allow the discussion and debate in Parliament, is a law that in a core central way is much, much, much stricter than the GDPR. Now, in Europe, estimates would say that 90 to 95% of all personal data processing happens under Article 6, I think it is E, which is the legitimate interest ground, which is what the vast, now there's a public interest test also within legitimate interest. It's a balancing test between the private interest, public interest, the interest of the person involved, etc. Okay, it's a balancing test is how it's been interpreted by the EDPS and so on. That ground of legitimate interest is not present in the Indian law. So under Indian law, pretty much the only two ways that private companies for regular business processing can process data would be either A, with your explicit consent, or B, with implied or implicit consent. And even implicit consent is narrowly defined. It has to be for the same purpose as the data was originally provided, and so on. And the vast majority of data that's being processed and used and collected by companies, by NGOs, by anything that is non-governmental, would not fall directly within either explicit or implicit consent. As I said, the main ground for all data processing in the EU is legitimate interest. So we have a data protection regime that is much stricter. Now, even take the process of anonymizing data. So you have data that has personal data. If it is anonymous data which does not have personal data in it, then you're free to process it. But your source has personal data. Even anonymizing data is actually processing of personal data. And in order to anonymize someone's personal data, you need their consent. So you can't even anonymize, even get rid of their personal data without their permission, which is a ridiculous state of affairs. You can't say, okay, it's good for that person if I anonymize their data. I don't need to take their permission to get rid of their data from a data set. Except the law that has been passed in India requires permission to not use someone's data to get rid of their data from your database, from your data set. Yeah. So it's a rather strange law that's been passed that, if read literally, will lead to very absurd consequences. And at the same time, the Indian government is passing all these AI governance guidelines, which got passed earlier this week and so on last week. And what AI, how can you have AI without, most forms of AI require large quantities of data from the publicly available web. And if you can't process that data, if you can't even remove personal data from that in order to use within your AI models, then we can't quite talk about AI. And this, in fact, affects not just AI, but even search engines, because even search engines are based on legitimate interests as the ground. All kinds of data processing happens under that main single ground. Yeah, sorry.
And Philippines has the broadest legitimate interest interpretation?
That is when it comes to copyright.
I see.
So under, now the similar kinds of problems as with at least most of the countries here, when they do have a data protection law, do contain legitimate interest, because very many of us have taken directly from the GDPR, and legitimate interest was there in the precursor to GDPR as well. In the 90s, European data law, which I'm forgetting, the directive whose name I'm forgetting right now. But in copyright, most of our countries follow the system of what is called fair dealing and specific exceptions in copyright law. Now, in copyright law, reproduction is prohibited. How is a search engine made? A search engine first reproduces all manners of website, billions of websites, now it's trillions actually, of web pages, individual pages get copied by a search engine. Then they train models to search through by crunching and through statistical analysis. Of that, they create another artifact, and then the actual search happens on that artifact. So first you have to copy and then perform statistical analysis, data computation, and then the searching actually happens. Without that, search engines would not be possible. Except copyright law prohibits copying. Right? And everything. Now you would say, okay, you can copy, but don't copy songs and movies and you know, copyrighted stuff. But that's not the way copyright law works. Anything and everything that has the minimal amount of creativity in it is copyrighted. The moment you put pen to paper and I write anything, the moment you send out meaningless tweets when you're drunk, all those tweets, everything is copyrighted, whether you realize it or not. You might not mean for it to be copyrighted, but it automatically is. You don't need to go to a copyright office and say, I want this to be copyrighted. Automatically, under international treaties like the Berne Convention and the TRIPS Agreement, whatever you produce is automatically copyrighted. So the only things which are not within copyright, definitively, would be things which are made before, say, 1930s. So all the written material and all the movies made before the 1930s and text and songs and everything, only that is outside of copyright law. Everything on the public web that is post-1930s is copyrighted, and hence you cannot actually reproduce, etc., unless it falls within an exception in your copyright regime. And most of our laws, other than the Philippines, which is a notable exception, contain limited exceptions, contain specific exceptions, an exception for education, an exception for private research, an exception for photographs of public architecture, etc., etc. They contain narrow exceptions and a list of these kinds of exceptions. What Philippines has done correctly is to take the US model. Now, the best model, in my opinion, is a combination of our systems with the US model. What is the US model? It is where they can have some specific exceptions for, say, disability rights and so on, but they also have a general exception which is called fair use, where they just say these are the factors, here are the 4 factors you need to consider. How much copying, what is the kind of copying, was it for commercial use? Is it a substitute to what is originally, to the original copyrighted work or not? These kinds of factors are provided for in the law, and the court can decide based on those factors. So that's the best kind of copyright, system of copyright exceptions. You have specific exceptions for when you can specify that there are going to be problems with regard to access for persons with disabilities. So we need a specific exception for that. We need an exception for education. We need an exception for certain things like private research. We need an exception for interoperability of software. So you have all these specific exceptions, but you also have a general catch-all broad exception. The only country in our region, in South and Southeast Asia, that has that is the Philippines. I believe Singapore might also, I'm not sure, and I think South Korea might also have it, but Israel has it, the US has it, and the Philippines definitely has it. So these 3 countries, and you can count on your 2 hands the number of countries that have a fair use system. All countries, we believe, should go to that kind of flexible system for exceptions, in addition to a specific set of exceptions. That will allow for, when you can't predict things, no one could have predicted AI of the current form, say, 15 years ago. Yet laws written 15 years ago need to accommodate this. Those countries where there are these kinds of flexible exceptions can deal with changing technologies in a way that our copyright laws cannot.
I mean, whether our copyright laws are always enforced when it comes to AI use is another question I guess we can ask. So what does that actually mean? Does that mean in a practical way that the training data sets are likely to come from these countries that have broad fair use policies, for example? Because that's not necessarily what's actually happening.
So even if OpenAI, an American company, trains their data sets in the US, making use of US law, they can still be sued and are currently being sued in India because there's material that is protected under Indian copyright law, which they have used. So as long as you're doing business outside of just the US, outside of just Israel and the Philippines, as long as you're doing business in some other country where the copyright law is not as broad, you're still going to face a problem. What's the solution? Our countries, at a minimum, apart from a general exception like this, need to provide a specific exception. Now, copyright law is meant for when humans are actually doing the copying, doing the reproducing, doing the communication to the public being humans, are doing the translating, etc. When it is machines, so when it's for use as training data, when it's for use for, say, academic statistical analysis and research, when you're doing any kind of copying solely for machines and not for humans to consume, not for humans to read, that should be exempted because copyright law was never meant to cover it. It's only because technology has changed that we ended up in this situation. And read literally, laws written with keeping humans in mind actually apply to machines as well, because it doesn't say this is applicable only to human beings. It's generally written, and it doesn't say reproducing for the benefit of humans, even though that's the intention, right? It just says reproducing. So there should be a general exception, a specific exception, sorry, for text and data mining. There are multiple countries which have, all of the EU countries have implemented such exceptions. Japan is a good example for a text and data mining exception. So multiple countries, advanced countries have these exceptions, and our countries also need such an exception for when machines are the consumers of copyrighted material rather than human beings.
Shakti, did you want to come in quickly?
Yeah, as one of the biggest OpenAI users, Indonesia has not been doing any radical progress on regulating this. But just last August, the government under the Ministry of Communication and Digital launched like the roadmap of AI adoption in Indonesia. So hearing this discussion, I think Indonesia is still a bit far behind, but they are more on, like sharing and bringing more awareness on ethical use of the open AI. So we can learn a lot of the other countries' progress and how they see this going forward.
One very quick point. Apart from removing obstacles for companies, governments can make it easier as well by creating data sources in local languages, in your own language, for technology companies to actually use and say, here are data sources that we've put together in the myriad languages of India, in Sinhala, etc., that you can use, and we're guaranteeing as governments that this is not within the scope of copyright protection for the purposes of training. So you can go a step further as well to make sure that your languages are included and that AI models actually work with your own data sets as well for inclusivity and so on.
Any last questions? And I have one last question for the panel.
So I think to add to Pranesh's point earlier on the copyright thing, reproduction and transformation, I think clearly needs to be understood. And the case in US is Baths versus Anthropic. And there are now 59 cases in US relating to AI companies violating or allegedly violating copyright. So the fair use, so 2 issues in this case was taken up by judge. And fair use was allowed because it's not a complete reproduction of the author's books. So Anthropic copied 7 million books from 2 shadowy libraries, Pilimi and LibGen. And the judge said, still, it's fair use because GPT, we need to understand, generative pre-trained transformer. So transformation is happening and it's not the same thing the outcome is. So based on outcome, it's fair use. Yeah. And the second point in that case is the illegal use or downloading of the 7 million copies or part of it by the company Anthropic and keeping it in the server. So that was actually the illegal part, which went to a 1.5 million billion settlement in US. Yeah. And all these cases you can find out in ChatGPT's eatintheworld.com. All are reported.
Fantastic. Any other questions? There's one, Udakara, mic there. Oh yeah, there's a mic here. Yeah.
Hi, sorry, my name's Pooja, former UN, former Gov, and currently I work for a Big Four. I have a quick question. I know we spoke about data governance, the RTI, and a lot of technical stuff, and I really do appreciate this forum. I think this is one of the most interesting things I've ever attended for the whole year, so thank you so much. This is about the government cloud, the LGC 2.0, which thanks to ICTA, they're doing their works, but my question is, what exactly is the LGC 2.0 under? Which policy? Is it an amalgamation of policies? Is there one policy? And also, yes, we do have these policies in draft forms or whatever it is, but without this cloud, do you really reckon any of these policies would be effective, is my other question. Coming from government on a day-to-day basis, whenever the administration changes, which Sri Lanka has had a couple of its changes, administration to administration, there's no transparency. The data doesn't quite effectively get forwarded to the next administration. Within departments, within ministries, everyone's working in silos. These are actual issues, and I just wanted to bring it up just out of curiosity. Just wanted to see what you guys think. Thank you.
Any other questions at the back? If not, we should address this government cloud situation. Yes.
So the first part of your question is about under which policy. So I did mention it. It's the Sri Lanka that's got this architecture framework. Version 1 was available, and of course it's again a draft one. That did mention and does mention the Lanka government cloud. And then we also have a cloud policy along with a strategy that was published in June this year, again in draft form, that was open for public consultation. That incorporates not just Lanka government cloud, but it's also a general cloud strategy and policy, which of course says that it doesn't have to be it doesn't have to be stored locally. You can store it outside of the country. And it also mentions that the data that's being stored has to be classified. It doesn't say what can be classified or what the specifics have not been entered into, but they just say you can classify it as confidential, restricted data, data that can be freely stored elsewhere, etc. It incorporates that. So we have these draft policies on Lanka government cloud. And there was also another cloud policy that came about in 2023, but I don't think it's accessible anymore. So we have a plethora of policies, but I do agree when it comes to changes between government and administration, there is opacity. We don't really know enough about how these changes are being implemented and whether they do have enough information that they should be having.
I mean, maybe you should also connect with Rohan, who's sitting up here. There's the question of a government agency with capacity providing cloud infrastructure for other government agencies as a service, because not everyone can keep doing it for themselves. There are then questions about the competency of actually doing that, where that is hosted, and what kind of data should you mandate be there versus commercially negotiated cloud service providers, right? I think there's a sort of a whole series of questions we really do need to answer there. And who pays for it and so on. I will wrap up, and please talk to the speakers afterwards. But I just want to ask one question, which I actually didn't ask you all before, because I always ask this in many panels, like if you were all powerful and you had the magic wand, what is the one thing you would change to have a better data governance ecosystem in your country? You can get it done. What is the one thing? It can be a section in a law, it can be anything, doesn't matter. But priority thing that will really improve, I don't know, whatever, transparency, data quality, AI and enable it, etc.
Maybe I can start.
Yes.
In case of Indonesia, I think one of the things that I believe can change the data governance ecosystem is the capacity. Because, like when other countries started to, doing radical changes and advance on the technicalities, and we still discussing on where to go. So if there is one thing I can think of is the capacity, the excellent capacity, so they can shape where the country goes on this. Yeah.
Okay, thank you. Semanta.
I'll be very brief and quick. From an e-governance angle and data governance angle, I think there are 4 pillars to that, to have an effective e-governance setup. First pillar is to have a good access to...
You get to change one thing.
So just change one thing. So first thing is to have the digital interconnection, the access to internet, that is there. Second thing is to have...
So that's what you would prioritize. No, get to the one thing.
So last is the only thing is, you have a service delivery app, but if the government, different government machineries cannot exchange data, the service delivery app cannot function. So I think we should have a effective sharing of data between the government agencies.
Wonderful, which includes, of course, then interoperability and standards and all of that. Okay, thank you. Aslam?
Looking at all the laws and policies of Pakistan, I think what I would do, one thing is either take out the national security and public interest out of those laws or define them. That's all.
Right. Okay, fantastic. Thank you.
Can I say 2? I'm just going to quickly just...
This is an event about
Sri Lanka, so we'll change 2. We have 2. Yeah. Just number 1 is, of course, I would, we have explanations to what constitutes public interest under the Personal Data Protection Act. And they're rather limited. There are 2 areas which I believe I anticipate there'll be massive development if we can include those 2 as examples of public interest. One is in terms of use for journalistic processing. And the other one is to have a more well-defined one for right to information as an exception. Because it's a general one under Section 35. I would think it can come up in terms of an advisory committee, guideline, or anything like that. Those 2, I think, would massively develop.
Great, thank you. Pranesh?
I'd want, in terms of actual policy stuff, I could say everything from AI and copyright, AI data protection, and multiple open source things, policies which require to be laws. Okay, those are things I could have talked about.
Okay.
But
clever approach, yes.
Instead, I'd say the one thing that's necessary in India and elsewhere is having a good policy-making process with all the things that I listed on my slide, with proper justification and so on. If that were completely followed with public participation, because there are more than enough people, at least in India, and I imagine at least look at all of us deeply engaged in policy-making here, who want to contribute to improved policy-making, and their private sector interests in that as well. That will result in better policies, in better laws. Currently, the policy-making framework is greatly broken in most of our countries. It works well in patches here and there, but we need to get that properly followed. And for that, in many cases, you need statutory protection. In India, we do have an open policy-making policy, but which requires drafts to be published and so on. But if that isn't done, if drafts aren't published, you don't have any recourse as a citizen. You can't go to court to enforce that because it's only a policy, it's not a law. So fixing that, I think, will go a great way in fixing many of the other sector-specific issues.
Fantastic, thank you. So please join me and thank the panel with applause. Thank you to all of you for coming. I obviously need to thank our research funders, the International Development Research Center. Do engage with the report. This is an area that we continue to work in, both just looking at laws and policies, but practically trying to access and use data when we do our AI models. So this is a lot of what we do at LIRNEasia, sort of bridging that policy and practicality of some of these angles. Thank you very much. Have a lovely evening, everyone. Thanks.